Question number 26. Pending decision on the objections to an arbitral award, an application for appointment of receiver may be proved, cannot be filed as a matter of right, may be moved with the special leave of the court, both second and third. Correct answer is option first, may be moved. Question number 27. An arbitral award may be set aside in the court if it is in conflict with the public policy of India, a party under the same incapacity, it is held by the local court holiday. Both 1 and 2nd, that is option 4 is the correct answer. Mercenary profits are defined under section 2 clause 12 of CPC, means those profits which the person in wrongful possession of such property actually received or might have received together with interest. Option first is the correct answer. Question number 29. On production of a certified copy of a foreign judgment, the presumption as to the competency of the court under section 14 of CPC is a presumption of fact and law both, rebuttable presumption of law, irrebuttable presumption of law. Here the correct answer is 29(3), rebuttable presumption of law. Question number 30. Mark the incorrect proposition. Set off is a statutory defense to plaintiff's action where a counterclaim is cross action. Set off and counterclaim arise out of the same transaction. Set off should not be barred on the date of the suit, while the counterclaim should not be barred on the date of filing of written statement. Claim for set off cannot exceed plaintiff's claim, whereas counterclaim exceed the plaintiff's claim. Both set off and counterclaim cannot exceed the pecuniary jurisdiction of the court. Select the correct answer using the code below. Correct answer is option 2nd, that is B only. Set off and counterclaim arise out of the same transaction. This is the incorrect proposition. Other options are correct, that is A, C, D, E is correct, and this proposition is not correct. That is why this is the right answer. Question number 31. Mark the correct statement. The question which are put only to test the credibility of a person will not be allowed as interrogatories, although they may be asked in cross-examination. Interrogatories may be administered only to a party to a suit and not to a witness, whereas cross-examination can be of any person, parties or witness alike. A party filing affidavit in reply to interrogatories can neither cross-examine nor adduce evidence to contradict it, as it is a conclusive proof. All of these. Now let us see the question number 32. An executing court cannot determine the questions relating to which of the following. Options are execution of decree, discharge of decree, satisfaction of decree, modification of decree. Here the correct answer is option 4, that is modification of decree. Question number 33. Which of the following statement is correct? An attachment order come to an end by A. Satisfaction of decree, B. Setting aside or reversal of decree, C. Dismissal of execution application for decrees holder's default, and E. Death of decree holder, E. Agreement compromise between the parties. Select the correct answer given the code below. Here the correct statement, that is correct answer is option A, that is A, B, C and E. Option D is not the correct answer. Other statement A, B, C and E is the correct statement. Which of the following statement is correct? An appeal pending before an appellate court does not by itself operate as stay of the proceedings under decree appealed from. The appellate court has a power to stay the execution of such decree. Third option, both 1 and 2, and option 4, none of the above. Here the correct answer is option 3, that is both 1 and 2. Which of the following orders cannot be appealed against under the Code of Civil Procedure? An order to set aside for dismissal of suit, an order to set aside decree passed ex parte, an order for a grant of temporary injunction, none of the above. Correct answer is option 4, that is none of these. Question number 36. Which of the following propositions is incorrect with regard to the oral examination of property by a court under Order 10 Rule 2 CPC? The examination need not be restricted to allegations in a pleadings of the other party but can relate elucidating any matter in controversy by the suit. The court can examine not only the parties but any person accompanying either party to the suit. The statement made during the course of examination is not an oath. The court can cross-examine any of the parties with reference to document. Here, the incorrect statement with regard to oral examination is option 4, that is the court can cross-examine any of these parties with reference to document. This is the right answer, but other statement 1, 2 and 3 is the right answer. Right statements, but option 4 is the right answer. Under section 152, an order can be corrected by the court where there has been a clerical mistake, an arithmetical mistake, an error caused by an accidental slip or omission, all of these. Correct answer is all of these. Section 152 CRPC, clerical or arithmetical mistakes in judgments, decree or order, or errors arising therein from any accidental slip or omission may at any time be corrected by the court either of its own notion or on the application of any of the parties. Question number 38. Provision of section 304 of the Code of Criminal Procedure applies only when in a trial before the accused is not represented by a pleader and it appears that he does not have sufficient means to engage a pleader. Correct answer is option 2, Code of Session. Section 304 of CRPC talks about the legal aid to the accused at a state expense in certain cases. Now let us see the question number 39. A magistrate to whom a complaint is made under section 340 and 341 of the Code of Criminal Procedure shall proceed as far as may be to deal with the case as if it were instituted on a police report. This is the correct answer. Question number 40. Filing of FIR is a condition precedent to the exercise of power under section 438 of the Code of Criminal Procedure. The statement is true, false, partly correct, none of these. Correct answer is false. Question number 41. A magistrate has the power under the Code of Criminal Procedure to direct the police to investigate into a non-cognizable offence, cognizable offence, only a non-cognizable offence. As in a cognizable offence, the police is under the duty to investigate for both 1 and 2. Correct answer is option 4, both 1 and 2, a non-cognizable offence and cognizable offence. Question number 42. A case which includes cognizable offence and non-cognizable offence is a cognizable case but requires sanction of the magistrate for investigation into a non-cognizable part. Option second, cognizable case and as such the investigation of the case does not require any sanction of the magistrate. And option 3, non-cognizable case and as such the investigation of the case requires sanction of the magistrate. And option 4, non-cognizable of the case but does not require any sanction of the magistrate. Here the correct answer is option second, that is cognizable case and as such the investigation of the case does not require any sanction of the magistrate. Question number 43. For the purpose of computation of the period of 90 days or 60 days as the case may be, for the purposes of section 167 subsection 2 of Code of Criminal Procedure, the day of arrest of the accused has to be excluded, on which the accused has remanded is to be excluded, of the arrest accused and the day on which the accused was remanded indifferent, both have to be excluded. Correct answer is option 3rd. Question number 44. Non-compliance with the provision under section 191 of the Code of Criminal Procedure where cognizance is taken by the magistrate under section 190 subsection 1 clause C of the Code of Criminal Procedure. Option first, vitiates the trial and proceedings and will be wholly void, is an irregularity curable under section 460 of criminal procedure, does not vitiate the trial unless it has caused the prejudice to the accused, amounts to waiver of his rights of the accused. Here the correct answer is option first, vitiates the trial of the proceedings will be wholly void. Question number 45. When is an investigation officer bound to videograph the proceedings during the investigation? Options are identification of the driver of the offending vehicle by physically disabled victim of road accident. Option second, recording of the statement of rape victim under the mental trauma, both 1 and 2 and none of these. Correct answer is option first, identification of the driver of the offending vehicle by the physically disabled victim of road accident. Question number 46. Sanctions for prosecution of judges and public servants shall not be required under section 197 of CRPC in a case a judge or public servant is alleged to have committed. Correct answer is option first, voyeurism. Section 197 in detail discuss the provision of prosecution of judges and public servant. Now let us see the question number 47. All evidences taken in course of trial shall be taken in the presence of the accused except in the following circumstances: a minor girl victim of kidnapping, an old person witness of murder, a minor girl victim of rape, a physically handicapped woman victim of road accident. Correct answer is option 3rd, that is a minor girl victim of rape. Question number 48. A intending to murder B by poisoning purchases poison and mixes the same with a glass of water. He gives the glass to the bearer to serve B. The bearer, while approaching B, loses balance and the glass drops out of his plate. Which one of the following statement is correct? A has committed no offence. A has committed the offence of attempt to commit culpable homicide. A has committed the offence of abetment. A has committed the offence of murder. And question number 48, correct answer is option 4. A has committed the offence of attempt to murder. Question number 49. Planning to commit theft is a cognizable offence, no offence in itself, strict criminal liability, conspiracy. Correct answer is no offence in itself. Question number 50. An accused person was charged under section 302 read with section 149 IPC. The existence of common intention among the accused person was established from the surrounding circumstances and from their conduct on the spot. No charge had been framed under section 34 IPC. In such case, it is not possible to convict the accused with the aid of section 34. It is possible to convict the accused with the aid of section 34. Second option is the correct answer.